morning. Welcome everybody to our webinar about increasing pet rights for tenants in body corporate properties. My name is Matthew Savage and I'm the Strata Operations Manager here at BCsystems. Just like to say, firstly, thank you for joining. This is the first time we've organised a webinar like this to do a training topic on a body corporate issue. So appreciate you all taking the time out of your days to join us. We would love to hear some feedback at the end of the session from you about whether you've found this beneficial, what you thought about the format, and if there's anything you'd like to hear us discuss, in a future session. We'd love to have an opportunity to do this regularly, and get some knowledge sharing happening between our body corporate managers and our valued clients. So I'll jump into the presentation now. If you've got any issues with audio or video or anything like that, pop it in chat, and I'll just share my screen, which I hope you can see this PowerPoint slide. Okay, so new pet rules for tenants in body corporate properties. Let's get going. So just a bit about us before we do. BCsystems is a body corporate management firm based in Brisbane in Morningside, and we operate in southeast Queensland. I'm guessing most of you have heard with us or deal with us on some properties at least, and that's how you came to be here today. But if this link has been shared with you by a different contact in the industry, then welcome. We are Brisbane's #1 rated strata management company, and we've got a 4.9 stars on Google, which we're very proud of. We operate in Brisbane and the Gold Coast primarily, but we can and do manage body corporate properties across Queensland. Like real estate agencies and all of you, most of our new business comes from referrals. So we're always happy to talk to any clients you might have, mutual clients. If they're looking for a strata management solution, very happy to have a discussion with you or anybody you'd like to refer our way. We try and make that a mutual relationship as well. Look, before I get started, if you've got any questions throughout today on this topic or any other topic related to tenancies and strata, please just pop them in the chat. So just hit the chat and type your question in there, and we'll come to those at the end. Okay, so there's new legislation that's been approved for tenancies in Queensland. The legislation commences on the 1st of October. Now, as property professionals, I'm confident you've all heard about this already, probably a fair bit. So I'm not going to talk necessarily about all of the changes, but there is a specific change relating to pets in body corporate properties, which I don't think has received the attention it probably needs to hear. So that's what we're talking about today. So from the 1st of October this year, there will be a change which means landlords or rental property owners are unable to apply a blanket ban on pets within their rental property. So this is the bit you would know about. There will be a specific RTA form for a tenant to use to apply to the property owner to keep a pet within their rental property. And then landlords must consider all applications based on the individual merits. So the old days of landlords having a no pets policy are gone, or will be gone, and tenants will have an opportunity to apply for pets, even though the landlord may not like that very much. The landlord must give the tenant an answer within 14 days of receiving that request. If they don't respond, the law considers that the pet has been automatically approved by the landlord. So if the landlord doesn't reply at all, it's taken to be a deemed approval. And applications for tenants or applications for pets from tenants can only be refused by the landlord based on a specific list of prescribed grounds. That really restricts the way that the landlord can reply to these applications. These are the grounds. So these are set out in that new section 184E of the Residential Tenancies and Rooming Accommodation Act. So this is the piece of legislation that's been amended. So there's eight grounds. These are the grounds on which a landlord can refuse a pet. So most of them are pretty self-explanatory. Number 6 is the one that we're talking about today. So if keeping the pet would contravene a body corporate bylaw or a park rule applying to the premises. A park rule relates to movable dwellings or caravan parks, so that's not the subject of today, but we're talking about body corporate bylaws. So first and foremost, the bylaws in a particular body corporate scheme would overrule a tenant's right. So if a tenant has a right under that Residential Tenancies and Rooming Accommodation Act, if that's inconsistent with the body corporate bylaw, the body corporate bylaw takes precedent. So whilst body corporate blanket bans on pets are not common, most bodies corporate have some type of restriction or regulation on the type of pet, the number of pet, how the pet can operate within the body corporate. And there's often lots of hoops to jump through in order to get a pet in a body corporate property. So there's generally a requirement to obtain committee approval for each pet. There's often a requirement to register that pet or make that pet known to the on-site manager or caretaker if there is one at the property. And then the sort of obvious restrictions on the number of pets, the type of pet, and then some conditions about what the pet can do and when it's living on the site. If any aspect of the landlord's approval of a pet and the body corporate bylaws are inconsistent, the body corporate bylaws win. So that's taken up in that in the grounds for refusal, where a landlord can't give an approval that's inconsistent with the body corporate bylaw. So some examples here: if the tenant applies for a pet and receives approval from the lot owner, from the landlord, to keep a second pet, and the body corporate bylaws only allow residents to keep one pet, well, that tenant would be in breach of the body corporate bylaws, even though the landlord may have approved it. In example 2, if the body corporate bylaws require committee approval for residents to keep a pet, and the tenant only receives approval from the landlord and then brings the pet into the building, the tenant would then be in breach and must remove the pet from the scheme until the body corporate approval is received. So that's the context, and then we're going to talk about how to navigate this particular issue. So that's why we're here today. A guide for general property managers. So on the line, we've got general property managers who work for a real estate business managing, a few hundred properties across all different buildings. And we've also got some on-site managers on the line. So they typically will look after a number of rental properties within one or two specific body corporate properties. So the issues facing the two are the same, the legislation is the same, but you've probably got a little bit different circumstances when it comes to how well you know each individual building. So the first guide we would give is to conduct a file audit to make sure that you've got a current copy of the Community Management Statement, the CMS, which includes the current bylaws for every building in which you've got a rental property under management. So if you're a business that has, 400 rentals and 200 of those are apartments or units or townhouses, then you may need to have 200 different sets of bylaws in the office and keep those up to date to make sure that you know what the bylaws are for that particular body corporate. Step 2, definitely recommend proactively informing your landlords or your clients about how you plan to handle pet applications. I would definitely remind them that there may also be a body corporate process that involves that lot owner having to do something on behalf of their tenant, depending on the individual bylaws. So in some cases, the landlord just gives a tick and flick to the tenant saying, yes, I'm happy with that outcome. In some other cases, the landlord may need to go and make an application to their body corporate to get approval on behalf of the tenant to keep that pet. So depending on how the bylaw is written, sometimes the landlord may need to be quite involved in that process and talk to the committee about approving the pet and confirm that the landlord has approved the pet. If you've got a bylaw that requires committee approval for the pet, make sure you've got the application forms handy. So BCsystems clients, we've got an online pet application form. Most other body corporate managers should have the same. In some particular buildings, they have their own pet application form, which is specific to their building. So if that's the case, I would get a copy of that and keep it on file so that you're ready to go applying for the body corporate approval if that is required. And point 4, the fourth biggest point, is understand and advise the tenant about the decision timeframes. So we'll talk about this a bit later on, but the landlord under the under the tenancy legislation, must provide an answer to the tenant within 14 days. So application comes in, the landlord's got 14 days to decide and respond. If they don't respond, it's a deemed approval. However, the body corporate committee under the law has 6 weeks to start considering the application, and then may take a further 3-week period to make the decision if they don't make that decision at a formal meeting. So that's a bit technical, but 6 to 9 weeks for body corporate, 14 days for the landlord. So there's a massive difference in timeframes there, which will cause issues. So finding the correct bylaws. My history, I've been a body corporate manager for a decade, but prior to that, I worked as a rental property manager for 5 years at a real estate agency business in West End. And I am ashamed to admit that our office for 5 years gave a single document called bylaws to every single tenant in every property, and it was the same document. So at that time, the business owner did not understand, and neither did we, that bylaws could be unique. So what we were giving to tenants was not the bylaws for their own body corporate. So it's important to have the correct bylaws. Bylaws are found in the community management statement, or the CMS, and that provides a whole range of information about the body corporate. It's got their name, a list of all the lots or the units in the scheme, the plan numbers, it's got the lot entitlements, the bylaws and exclusive use areas. And this is just a little picture of the front page of those documents. So you'll note it has a barcode at the top left and a big dealing number, and which shows that this is a registered document with the titles office. If you've got a document that doesn't look like this, it's probably not the correct document for that particular body corporate. This is another example. I've just pulled a few different pages out of a CMS to show you what they look like. Now this is a bit trimmed down. So here we've got the front page, a list of all the lots, a list of their entitlements, and then it goes into the bylaws in sort of a paragraph format. And then at the end, we've got the exclusive use areas and any plans or diagrams. So this is the type of document that you should have on file for any rental property which is within a body corporate scheme. If your document in the office for a building has only bylaws in it, and what I mean by that is if it doesn't have all of that other stuff, the lists and the schedules and the exclusive use, or if it says on it it's Schedule 3 bylaws or Schedule 4 bylaws, that is probably not the correct set of bylaws for that building, and further investigation is required. So Schedule 3 bylaws and Schedule 4 bylaws are a default set of bylaws in the body corporate legislation, and they only apply if a body corporate has no bylaws of its own. So in the last decade, and in my experience and across all of the buildings that we look after at BCsystems, I don't think we've got any buildings that use these Schedule 3 or Schedule 4 bylaws. But that said, we do see them circulated among owners and tenants and property managers, and it's often brought to our attention to say, look, these are the bylaws and we have to correct that misunderstanding. So if you've got these types of documents in your real estate business, I would not be relying on them, and I'd be doing some further investigation. If you don't have a copy of the bylaws, or if you're unsure whether your copy is current or not, you could ask your rental property owner to provide a copy to you. So under the law, the body corporate has to give a copy of its bylaws to the owner of each lot if they change. So most owners should at some stage have a copy, either from their purchase or if it's been updated since, or ask the body corporate manager for that building to supply you with a copy. There's no privacy surrounding bylaws or community management statements. There may be a fee payable to the body corporate manager, but it is in the body corporate's best interests for every tenant and agent to have a copy of the bylaws, because it makes enforcement a lot easier. Or you can order a copy of the verified CMS from a land title supplier. So if you're unable to get it from the owner or the body corporate, you can order it yourself. And there are some resources available to make that order if you've got a land title supplier, or alternatively, that might be a question we deal with at the end. So risks involved in this bylaw issue, right? If the owner agent is required to give a copy of the bylaws to the tenant before they sign the lease, and they don't do that, or they do it incorrectly, then the tenant and the owner may both have a claim against the agent. And the obvious consequences there, if a tenant has signed a lease and has been given an incorrect bylaw, and that bylaw means they don't want to live in the property anymore because they can't have a pet, they may try and get out of that tenancy agreement on that basis. Then there'll be like loss of rental income and potential issues between the owner and their agent. So it is important to get this right. If you've got a number of units within the same building, the bylaws apply to all of those units. So I know for on-site managers, this is usually the case. You just get the document once and you run with it. But for general property management businesses, you might find that in each building, you've got 2 or 4 rentals, and you can then spread the cost of this process out across those 4 owners, and just make it a little bit easier for them to keep up to date. So common types of bylaws relating to pets. The first one's not so common, but it's worth mentioning. So that is if a body corporate has no pet bylaw at all. So if you've got that CMS document for a body corporate and you're confident it's the correct one and it doesn't mention pets at all, then there just is no pet bylaw. So some bylaws don't mention pets or animals. If something is not in the bylaws, then the rule for that does not exist. So if you have a building with no pet bylaw, then there's no specific restriction from the body corporate side about pets in that complex. And you would treat that as though you would a normal freestanding house for the purpose of pets. A second type is a permissive bylaw. So that is a bylaw where, and this is an example, so an occupier, meaning an owner or a tenant, may keep 1 dog or cat within the lot, and it must not go in the pool area, and it must not cause a nuisance to others. So that bylaw is permissive because it gives an approval and it gives some conditions. It's effectively a pre-approval, and it doesn't require a specific approval for each pet. Again, this is probably a less common type of bylaw, but they are out there. And then the third type here is a restrictive bylaw. This is what is most common. So this is where an owner must not keep any pet without the prior written approval of the body corporate. So this is the scenario which you're most likely to encounter, where any pet at all needs to go to the committee for approval, and the committee will give you a yes or a no answer, and they can also attach conditions if they do give it a yes answer. Inconsistency in the decision timeframe. So this is a really big factor which will come up, guarantee it, for everybody on this chat. So as I mentioned at the top, the rental owner landlord has a 14-day statutory time frame to make these decisions. The body corporate has a 6 to 9 week statutory time frame. Depending on how their meetings are organised, you may get an answer much earlier than that. But if the body corporate needs to take that time, it is within its rights to do that. What that means in practice is the tenant will get an answer from the owner, and that answer will generally need to be conditional on also getting a body corporate approval. As we all know, pets are often a very emotionally charged issue, and tenants generally expect a fast and positive response and generally don't like to wait, up to 2 or 3 months to receive an answer on a pet, particularly if it's a pet they already own, or if they've got a deposit paid on a puppy and they need to get an answer in 10 days. They're generally not very excited to get this sort of answer back from the body corporate. But that's just the nature of how bodies corporate operate. With a rental owner or a landlord, it's one person. With a body corporate, it's usually 7 people representing maybe 50 different owners. So it's a different style of process, and this is just how the law is structured. So we can't change this issue, but we need to have some strategies to make sure it doesn't cause problems. So as we discussed, the 14-day issue, the challenge that we expect to see is that most tenants will probably bring the pet into the property immediately after they get an approval from the owner. And the body corporate will then be left in a position where the tenant has a pet in the building and has the owner's approval, but doesn't have body corporate approval. The body corporate then, by law, must enforce a bylaw breach against the tenant. And the owner or the agent must also enforce a tenancy breach against the tenant, because any bylaw breach is automatically equal to a tenancy breach for the tenant. So one of the Form 18 general tenancy clauses says that the tenant must comply with all bylaws. So this is a gap in understanding that we expect to see, where tenants get excited when they hear from the landlord and they don't wait until they also get the body corporate approval. Body corporate also can say no. So the body corporate committee must make a decision on each application based on its own merits. If the body corporate declines an approval, then the pet is not approved and can't come into the body corporate community. The body corporate committee also does not need to give reasons for making a decision, and they generally don't give those reasons. So if this is the case in your particular situation, the body corporate will say yes or no. If it says no, that's probably all you'll get, and then that will have to go through to the tenant, and they probably won't be happy to hear it. There is therefore a right to appeal a decision of the body corporate, but it's a slow process, and most tenants won't be prepared to wait 4 to 6 months for an appeal outcome if they've just moved into a property and they want to get a pet, or they've got an existing pet and it's staying with a friend. So it just puts a time crunch on this process. Media coverage issues. Every tenant in Queensland is likely to know about their new rights. It's something that's already in the media. It was in the media when this legislation was approved a couple of years ago, but it's also back in the media now because these pet provisions are starting in October. So every tenant, I would say, is likely to know about these rights. There has been much less coverage about the impact in the body corporate communities and the way that the bylaws and the tenancy law interact with one another. So that's unlikely to get any media coverage, and therefore tenants are less likely to know about it. So the burden of explaining this to the tenant is going to fall back onto the property manager who the tenant deals with. And again, that's why we're here today. This will make this process an uphill battle for property managers and the industry, because they'll have to explain and overcome some of the excitement that tenants may feel when they hear that they can have a streamlined pet approval process. So what's likely to happen? Just as a bit of a summary, while the tenancy laws and tenants' rights are the same throughout Queensland, so every tenant in Queensland has the same rights, every set of body corporate bylaws are unique. So they're all different, which means that the resources and advice available to tenants and rental agents and owners is not going to be tailored to the individual bylaws of that particular building. So it will be general advice and not specific advice. And this means it's hard to follow that advice. Many pets are currently blocked from entering body corporate properties because the landlord has a personal no pets preference, and that's about to change. So a lot of the body corporate committees and owners are about to experience a real influx of applications. And so we're expecting that there will be a lot of changes and activity in each building in relation to pets. And it'll be the agents who are really involved in that process, getting these applications through to the committees, getting the decisions, and then communicating back and forth between the tenant, the owner, and the committee. The media attention will most likely result in a lot more applications. I think most tenants who have received a no pet rule from the landlord, now that this change is coming into effect and it is retrospective, so it does apply to existing tenancies as well, I think a lot more people are going to be applying for pets than they did previously. which means the volume will increase. It'll be important for agencies to be ready for this change of dynamics, where you're getting a lot more applications and having to manage these processes for properties which previously had a no pet rule. Even when the bylaws are correctly supplied by the rental property managers, the tenants, in my experience at least, rarely review the body corporate bylaws in detail and rarely consider their full effect before signing a lease. I think body corporate bylaws are often something that gets handed to a tenant. They sort of look at the front page and then sign the lease because they've already made a decision to move into that property. So it is something that the earlier can be communicated to a tenant, the better the outcome will be and the more understanding the tenant will have about what that body corporate's opinion of pets is like. That bylaw step in rental property leasing will therefore become much more important than it probably is today. And BCsystems will continue to work with our rental property stakeholders and on-site managers to try and achieve the best outcome for all stakeholders here. And that's the end of my little presentation. So happy to take any questions from the audience if we have some questions come through. As I said, if you've got any questions about the topic from today or any general bylaw or tenancy question in body corporate properties, feel free to pop them through and I'll do my best to answer them. If we can't answer anything today, we'll do a follow-up to any information that comes through. So I'll just end my share screen. Okay, so we've got some hands up. I might ask anybody who's got a question to pop it in the chat if you can.
The chat actually isn't working, so just pop in the Q&A section.
Okay, sorry, in the Q&A.
Thanks, Matt.
Okay, question about the slides. So copy of the slides. Look, we'll definitely provide the slides to everybody who's attended the webinar today. In addition to the slides, we have put some articles out on these topics and with some different targeted audiences. So on our BCsystems website, if you look at the article section, there's an article which is written for the benefit of owners. So it talks about if you're an owner or a landlord in a body corporate property, what these changes are likely to mean for you personally and how you can go about understanding the changes and navigating it when you get these requests from tenants. So if you're looking for internal resources for your office, you can refer to the slides that we'll send out to you. You're also, I would encourage you to share that type of article with your owners in rental properties. And as I mentioned earlier, I would start that process of sort of going through your database, your document management system as early as possible, because if you've got even one unit in a body corporate property, it's very likely that you'll need to know the answer to that bylaw position at some stage in the future. And so if you can get a head start on trying to get those documents and pulling them together, that would be my advice. But send the slides around. We've got the article for owners, and we've also got another article which is a similar version of the information but aimed at the property management industry, and that's something that we're quite happy for you to circulate among your office. It doesn't have any specific information about BCsystems clients, so it is applicable to all body corporate properties in Queensland. While some Q&As are coming through, I'll go to some of these ones here. All right, so could you briefly discuss breaches of pet bylaws and how they are generally handled? Okay, so the bylaw breach process, what generally happens there is there's often two different types of reasons. So the first reason is if a tenant has a pet and is not approved. So the pet isn't necessarily causing an issue or a nuisance, but someone just sees it, through the fence and says, hey, we didn't approve that pet. In that case, what we would generally do is say to the owner or the tenant, look, you need to get approval for this pet, make an application. And if the pet is already on site but has not yet been approved, then the body corporate committee would usually treat that as a new application. If the pet has come in and is already causing a nuisance, it's barking and it's, annoying people, then the committee would be probably unlikely to approve a pet in that situation. So any pet that's either not approved at all or is breaching the conditions that's causing a nuisance, the first step is to raise that with the tenant and to say to them, look, the pet is not cooperating with the bylaws and you need to improve its behavior. So that might be keeping it inside at night, or, if you can make a dog stop barking somehow, the tenant would have an opportunity to try that. If that first bylaw warning doesn't work, then the body corporate issues a bylaw contravention notice to the tenant, which is a breach notice, and will generally also ask the on-site manager or the property manager or the owner to issue a tenancy breach notice to the tenant as well. So the body corporate can go through its own process, but for tenants, it is quicker for the rental property manager to action that breach notice, because the body corporate doesn't have the ability to end a tenancy for a tenant, but obviously the owner and the property manager can if it's an ongoing issue. So that's how committees try and handle that situation. Okay, I've got another question. Basically, if any tenancy agreement is signed less than 11 weeks in advance of the start date, there is a possibility a decision will not be ready and the tenant isn't allowed to take the pet when they first move in. Will this statement be correct, and can we be told, or can be told to any applicant less than 11 weeks before moving in? Yeah, so time frame wise, the body corporate has that 6-week window to start the consideration. It then has a 3-week meeting time frame after that 6 weeks. So it doesn't always take that long. And that's really a worst case scenario, or nearly a worst case scenario. Most of the pet applications that come through to our office get handled usually within 2 weeks. And so that allows time for us to receive the application, type up the resolution, send it to the committee members. They have to vote on it and make a majority decision, circulate that to all owners in the body corporate, and then come back to us with their answer. So it's usually a 2-week process, but in some cases, if a body corporate committee has a meeting, say in 8 weeks from today, they usually won't want to make decisions on the fly, and they'll probably hold that off until they can discuss it at the meeting. So it is correct to say if a tenancy is signed, only 2 weeks before the start date, the tenant probably can't bring the pet in on the day they move in. They would need to wait until they receive the answer from the committee. Even if a lease is signed 11 weeks or 20 weeks out, I know that doesn't happen, but even if it did, that's not a guarantee that the committee would approve the pet. So what I would suggest in terms of signing leases is make sure the tenant understands upfront whether the pets need approval or not, assuming they have a pet, and talk them through the fact that they can't just bring the pet in on day one. Most committees are also, they like to see applications and processes followed in advance. If you've got a tenant who brings the pet in first and then asks for permission, a lot of committee members may end up offside because, that strategy of bring the pet in and ask for forgiveness rather than permission, that generally doesn't work so well in body corporate properties. Got a question, how do you determine what is a pet and how does the body corporate manage requests for chickens, for example? Okay, so one of the conditions for a landlord to accept or refuse pets or animals is that it has to be a pet. So like a donkey or a horse or a cow is not a pet, but it is an animal. So chickens, I think, would be classed as a pet, depending on the local council area of the property. So I know in Brisbane, certain properties can have a certain number of chickens depending on how big the land is. So I would say firstly, look at the council restrictions, because that's an even higher level of authority. So it's above the tenant, it's above the landlord, it's above the body corporate. If a pet is allowed within the local council area, then I would say take that application to the body corporate, and they will make a decision based on the needs of that building. So if you have a townhouse body corporate where everybody has a big backyard, that's obviously going to be a very different answer on chickens to a high rise in the CBD. So there's no set rule for that one, unfortunately, but it'll depend on the individual merits of each application. Got a question here. What drove this change? What group was lobbying for such a change? So look, this is a change to the rental tenancy rights. I think we are seeing a push in the Queensland government towards stronger rights for tenants. And if you've been watching, the newspaper, watching TV or reading the newspaper, you'll see there's a lot of focus on landlords are bad and tenants' rights need to be protected. So that seems to be the tide moving in favour of the tenant in Queensland at the moment. And that's probably a mark of our elected representatives have made that decision. So I would suggest that if anyone has a fundamental opposition to the way this works, the way to go about that would be to lobby your local member of parliament and try and effect a change at that level. It's certainly not something that the strata industry has been lobbying for or against, because the strata legislation and tenant legislation is obviously quite different. This change probably makes more sense if you're talking about houses on normal blocks of land, but it has created a right for tenants in strata properties as well, which is what we're focusing on today. Question about the size and height of approved pets. So can a restriction on size and height be put in place? The body corporate bylaws have to be reasonable and they cannot make arbitrary rules. So what we see is in the adjudication decisions in body corporate space, if a committee has a hard rule that a dog can't be more than 10 kilos, for example, that would generally be considered to be an arbitrary rule and would not be allowed as a decision-making factor, because there's no evidence that a 9.8 kilogram dog is any less of a nuisance than a 10.1 kilogram dog. So it can't be a specific rule and then that be applied without considering the individual pet. So, this is raised really often in the body corporate industry, and that's the discussion, that just because a dog is a particular breed or size or weight or whatever else doesn't mean it's going to fit in well with the community. So it could be a reason that the body corporate committee considers, but it can't just be a hard rule that, under no circumstances will we take a dog that weighs more than 10 kilos. Some bylaws will have, we talked about, they can be permissive and restrictive. Some bylaws will have a permissive, almost like a fast lane for approval, where if a dog is only one dog and it's under 10 kilos and it's older than 2 years old, it can automatically come in, and anything outside of those rules needs to go to the committee for approval. So that's something that you do see sometimes, or one pet is automatically approved, but 2 pets needs to get approval. But again, that's not the decision itself. That's just creating a fast track for some types of pets, which the committee is probably going to approve anyway. Have a look. If a tenant applies for a property to move in 1 week's time and their pet is still pending approval, what happens with the pet if the pet result is not approved after 4 weeks after they've moved in? Look, the tenancy process and the body corporate process are totally different. If a tenant moves into a property, the law says that they have read the bylaws and have understood them before they sign the lease. So that's the position that the law takes. If a tenant moves into a property, they understand the bylaws and they're taking a risk that the body corporate may say no to their pet. So if a tenant hasn't got an answer after 4 weeks, or the answer is a no and they have a pet, then they would be stuck in that position, and they would either have to try and end the tenancy, and probably pay break lease costs and find a new tenant, or they would have to try and appeal the body corporate's decision, and again then wait for that process to go through, and it is not a quick process. So if I was a tenant with a pet, I would be looking for a building that has a permissive bylaw structure, or I'd be making sure that I've got that approval in advance, and I've made the absolute best case that I can to get that pet approved. So there is, in talking about approval, not all pet approvals are equal. Some of them are really good and some of them are quite poor. So if you've got a tenant with a pet, they need to put a bit of effort into making that application, and that goes to things like having a picture of the pet, maybe a pet resume from the person who did the training or the previous place the pet lived, to say that if it was a dog, it didn't bark a lot, or to talk in advance about how you might keep a cat indoors at night so it doesn't go and kill the wildlife. So the more that tenants do, the more effort they put into the application process, will generally help them to get a more favourable outcome from the body corporate committee. But ultimately the committee makes whatever decision it thinks is reasonable, which might be a different decision to what the landlord says. If you've got any questions, any other questions, pop them in the Q&A, but I'll keep going through. Question here: can Bodies Corporate introduce a no pet bylaw? So there have been plenty of decisions in Queensland that say a blanket ban on pets is not a reasonable bylaw. So a bylaw can't be unreasonable or oppressive, and so that's the current legal position, that a body corporate can't introduce a new no pets bylaw. Having said that, nobody reads the bylaws when they get lodged, so the body corporate can really put in whatever bylaw it wants to, that the owners have approved. What happens there is, if you've got a tenant or an owner in a building that has a no pets bylaw, and they believe that is an unfair bylaw, they can go through that dispute resolution process with the body corporate commissioner and try and have that bylaw removed. But again, that is not a quick process, so that doesn't really provide an opportunity for a tenant to do that if they're only on a 6-month lease and if their dog has to stay with a friend while they're having a fight. So in practical terms, it's probably not something that the tenant would be able to counteract, even though some people may have a view that a no pet bylaw is not a reasonable thing for a body corporate to do. Got a few hands up in the chat, so if you've got your hand up with a question, pop it in the Q&A for me. Okay, well, looks like we might have answered all the questions that have come through so far. So if you've got anything else, ask it now. Otherwise, we might wrap up there. And as I said earlier, we'll send out a survey and a follow-up after the webinar today. This webinar has been recorded as well, so if you've had anybody in your team or any contacts you might think this is useful for, we will send a link out to everybody, and you can come in and watch the recording of the webinar as well, so no one's missed out. And as I said earlier, let us know what content you'd like us to work on. I think probably areas of maintenance and approval for improvements to lots is probably something we might look at next, but quite happy to take any suggestions or requests from the audience to see that we're focusing on the right topics that provide you some benefit in your work life. So with that, I just want to say thank you again to everybody for joining, and we'll see you next time. Thanks.